one separate not guilty on each charge.
And,
Is that how you prefer?
And that's what the sample form tells us. It says style of case, guilty, 4%. Style of case, not guilty,
Right,
etc.
that's typically how it's been done.
So may I, Your Honor?
Yes. And does Defendant Perez have verdict forms?
I distributed them this morning.
Oh.
We do not, because we were not contesting the state's forum, but we can certainly print them up.
All right, so normally I put the not guilty verdict first, but because there's 6012 has it in a particular order of what they're supposed to consider. First, second degree, next is aggravated battery, and then not guilty. When it's a step down, I usually have it consistent with the instructions. Any
That's fine.
concern about that? All right, so you'll have verdict forms for Mr. Perez later?
We will, Your Honor.
Okay. I'll leave them when we get back from them.
Okay.
Is everyone ready for the jury?
Yes, Your Honor.
I don't think you, oh, you're good.
No, after she reads the instructions. Yeah.
Judge, where do you want us to stand when she puts up her screen? I was thinking over there is one option, to be able to see it.
She probably doesn't know where the screen is.
The screen's gonna be right here.
Same place as before.
Over there doesn't work where you have been, or?
Well, it's fine, I just get criticized for being too close to the jury over there.
Well, just as long as it doesn't get in the jury box like it did before, Judge, I'm fine.
Okay. Good morning, ladies and gentlemen. You may be seated. Ladies and gentlemen, you have heard all of the evidence. It's now my duty to tell you the law that you must follow in this case. I have 25 written instructions that will be going back to the jury room with you. Instruction number 1. The law governing this case is contained in instructions that I am about to give you. It is your duty to follow the law as contained in these instructions. You must consider these instructions as a whole. You must not pick one instruction or parts of an instruction and disregard others. A copy of these instructions will be given to you when you begin your deliberations. Instruction number 2. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide the case. Instruction number 3. You must not concern yourself with the consequences of your verdict. Instruction number 4. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agrees. Your verdict must be unanimous. It is your duty to consult with one another and try to reach an agreement. However, you are not required to give up your individual judgment. Each of you must decide the case for yourself, but you must do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own view and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the purpose of reaching a verdict. You are the judges of the facts. Your sole interest is to ascertain the truth from the evidence in this case. Instruction number 5. You alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account the witness's truthfulness or untruthfulness, ability and opportunity to observe, memory, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony considered in the light of all the evidence in the case. Instruction number 6. You should consider each opinion received in evidence in this case and give it such weight as you think it deserves. If you should conclude that the reasons given in support of an opinion are not sound, or that for any other reason an opinion is not correct, you may disregard the opinion entirely. Instruction number 7. An expert witness is a witness who, by knowledge, skill, experience, training, or education, has become expert in a subject. An expert witness may be permitted to state an opinion as to that subject. You should consider each expert opinion and the reasons stated for the opinion, giving them such weight as you think they deserve. You may reject an opinion entirely if you conclude that it is unsound. Instruction number 8. Evidence has been admitted concerning a statement allegedly made by one or more of the defendants. Before you consider such statement for any purpose, you must determine that the statement was given voluntarily. In determining whether a statement was voluntarily given, you should consider if it was freely made and not induced by promise or threat. Instruction number 9. In this case, you must consider separately whether each of the defendants is guilty or not guilty. You should analyze what the evidence is the case shows with respect to each individual defendant separately. Even if you cannot agree upon a verdict as to one of the defendants or charges, you must return the verdict upon which you agree. Instruction number 10. Each crime charged in the information should be considered separately as to each defendant charged with that crime. Instruction number 11. The law presumes the defendants to be innocent unless and until you are satisfied beyond a reasonable doubt of the guilt of each of them. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. Instruction number 12. For you to find the defendant guilty of second-degree murder as charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. The defendant killed James Boyd. 2. The defendant knew that his acts created a strong probability of death or great bodily harm to James Boyd. 3. The defendant did not commit justifiable homicide by a public officer or employee or act in defense of another. And 4, this happened in New Mexico on or about the 16th day of March, 2014. Instruction number 13. Great bodily harm means an injury to a person that creates a high probability of death or results in serious disfigurement, or results in loss of any member or organ of the body, or results in permanent or prolonged impairment of the use of any member or organ of the body. Instruction number 14. In addition to the other elements of the crime of second-degree murder, the state must also prove to your satisfaction, beyond a reasonable doubt, that 1, the death was a foreseeable result of the defendant's act; 2, the act of the defendant was a significant cause of the death of James Boyd; the defendant's act was a significant cause of death if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside event, resulted in the death, and without which the death would not have occurred. There may be more than one significant cause of death. If the acts of 2 or more persons significantly contributed to the cause of death, each act is a significant cause of death. Instruction number 15. Evidence has been presented that the killing of James Boyd was justifiable homicide by a public officer or employee. The killing was justifiable homicide by a public officer or employee if 1, at the time of the killing, the defendant was a public officer or employee, and 2, the killing was committed while the defendant was performing his duties as a public officer or employee, and 3, the killing was committed while overcoming the actual resistance of James Boyd to the discharge of the legal duty to arrest James Boyd for the felony crime of aggravated assault on a peace officer, and 4, a reasonable person in the same circumstances as the defendant would have reasonably believed that James Boyd posed a threat of death or great bodily harm to the defendant or another person. The burden is on the state to prove beyond a reasonable doubt that the killing was not justifiable. If you have a reasonable doubt as to whether the killing was justifiable, you must find the defendant not guilty. Instruction number 16. The availability of less lethal tools at the scene is not relevant to your determination of whether the elements of justifiable homicide by a public officer or employee have been met. Instruction number 17. Evidence has been presented that the defendant killed James Boyd while defending another. The killing was in defense of another if 1, there was an appearance of immediate danger of death or great bodily harm to another officer as a result of James Boyd removing knives from his pockets during the execution of an arrest plan. 2, the defendant believed that another officer was in immediate danger of death or great bodily harm from James Boyd and killed James Boyd to prevent the death or great bodily harm. And 3, the apparent danger to the other officer would have caused a reasonable person in the same circumstances to act as the defendant did. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in defense of another. If you have a reasonable doubt as to whether the defendant acted in defense of another, you must find the defendant not guilty. Instruction number 18. Whether the actions of the person being defended played a role in creating the need to use force is not relevant to your determination of whether the elements of justifiable homicide by a public officer and/or the elements of justifiable homicide in defense of another have been met. Instruction number 19. For you to find defendant Sandy guilty of aggravated battery with a deadly weapon as charged as a lesser included offense to count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1, the defendant touched or applied force to James Boyd by shooting him with a firearm. 2, the defendant intended to injure James Boyd. 3, the defendant did not commit justifiable homicide by a public officer or employee, or act in defense of another. 4, this happened in New Mexico on or about the 16th day of March, 2014. Instruction number 20. For you to find defendant Sandy guilty of aggravated battery with great bodily harm as charged as a lesser included offense in count 1, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1, the defendant touched or applied force to James Boyd by shooting him with a firearm. 2, the defendant intended to injure James Boyd. 3, the defendant caused great bodily harm to James Boyd or acted in a way that would likely result in death or great bodily harm to James Boyd. 4, the defendant did not commit justifiable homicide by a public officer or employee or act in defense of another. 5, this happened in New Mexico on or about the 16th day of March of 2014. Instruction number 21. In addition to the other elements of second-degree murder and aggravated battery, the state must prove to your satisfaction beyond a reasonable doubt that the defendant acted intentionally when he committed the crime. A person acts intentionally when he purposely does an act which the law declares to be a crime. Whether the defendant acted intentionally may be inferred from all of the surrounding circumstances, such as the manner in which he acts, the means used, his conduct, and any statements made by him. Instruction number 22. The defendants cannot be held responsible for the independent decisions and actions of another officer. You shall disregard any witness opinion to the contrary. Instruction number 23. In this case, as to the charge of second-degree murder contained in count 1, there are 3 possible verdicts as to defendant Keith Sandy. 1, guilty of second-degree murder. 2, guilty of aggravated battery. 3, not guilty. Only one of the possible verdicts may be signed by you as to defendant Sandy. You must consider each of these crimes. You should be sure that you fully understand the elements of each crime before you deliberate further. You will then consider whether defendant Keith Sandy is guilty of the crime of second-degree murder. If you find him guilty of that crime, then that is the only form of verdict which is to be signed. If you have a reasonable doubt as to his guilt of that crime, you will go on to a consideration of the crime of aggravated battery. If you find him guilty of that crime, then that is the only form of verdict which should be signed. But if you have a reasonable doubt as to his guilt of the crime of aggravated battery, then you should find him not guilty and sign only the not guilty form. You may not find defendant Keith Sandy guilty of more than one of the foregoing crimes. If you have a reasonable doubt as to whether defendant Keith Sandy has committed any one of the crimes, you must determine that he is not guilty of that crime. If you find him not guilty of all of these crimes, you must return a verdict of not guilty. Instruction number 24. In this case, there are 2 possible verdicts as to defendant Dominique Perez. 1, guilty, and 2, not guilty. Only one of the possible verdict forms may be signed by you as to defendant Dominique Perez. If you have agreed upon one verdict as to defendant Dominique Perez, that form of verdict is the only form to be signed as to defendant Dominique Perez. The other form as to defendant Dominique Perez is to be left unsigned. Now the lawyers will argue the case. What is said in the arguments is not evidence. It is an opportunity for the lawyers to discuss the evidence and the law as I have instructed you. The state has the right to argue first. The defense may then argue, and the state may then reply. Ms. McGill?
Thank you, Your Honor. It's been a long 2.5 weeks. It's time for us to shut up here in about 3 hours and for you to speak. I want to start with whether you ever wondered why the statue of Lady Justice, the one holding the scales, has a blindfold. It is where the term blind justice comes from, and why she has a blindfold is that no matter what happens outside this courtroom, where in certain arenas there are people with power and influence who affect what happens in the world, here in this courtroom, in these four walls, in this jury box, Lady Justice is blind, and no matter who you are, no one should be above the law, even police officers. And no matter who you are, even if you're a homeless camper, no one should be beneath the protection of you. That's the charge I put on your hearts as you go forward in this particular case. We've talked about and heard from the witness stand that society gives police officers a tremendous amount of power. We give them guns, not just sidearms, but long guns, and we give them a license to kill. And as you heard from the witness stand, that license is limited, and strictly limited by the society itself to certain particular rules that they have to follow. And who decides what the rules are? It is not the police department that decides that. If there was a rogue police department that said, we want to start shooting people of a particular color or people of a particular race or a particular religion, the society would say that cannot happen. That cannot happen. The jury gets to decide what is reasonable. You have heard a huge difference from the different witnesses, the two experts, about where that line should be as far as when police officers can shoot somebody. But it is not the experts who decide where that line is. It is all of you who decide where that line is. And here's what you've heard as far as where the line is in this particular case. You've heard sort of an old school version of where the line should be, and you've heard the modern 2014 version of where APD drew the line in 2014 with its reactive control model. From our side, you've heard from two people about where the line is. SWAT Sergeant Jim Fox, who talked about the reactive control model and where the line should be, and Jeff Noble, the Deputy Chief from California, who came in and talked to you about where that line has to be. And then on the other side, you heard from the defense expert, a fellow named Ron McCarthy. Our side talked about the reactive control model. You'll recall Mr. McCarthy talked about anticipatory shooting, is what he talked about. That that's where the line should be drawn, that police officers should be given lots of leeway. What our folks said was verbal threats are not enough for deadly force. No matter what somebody says to you, no matter if they curse you out, no matter if they threaten your life, words alone are not enough to kill somebody. If you're going to kill somebody, it's not enough to have them. I'm sorry, Judge.
I'm having a disruption in the audience. Sir, you're causing disruption. You're going to need to leave. Sorry for the interruption.
Okay, it's all right, Judge. Nobody okay? All right. You can't kill just to kill. You have to have a reason. That's it. Okay. And you can't do it just on words. What did Mr. McCarthy said? Well, he said, and he gave me an example. I think police officers should shoot whenever they feel threatened. I remember the example he gave you about this fellow police officer on the beach, saw some guy walking up to him, just felt wrong about it. The guy reaches under his sweatshirt and the officer blasted him. And it turned out, in that case, the officer was right. They lifted up his shirt and there was a gun that had been taken off the police who'd been killed the day before. And when I asked Mr. McCarthy, but what if they lifted up his shirt and it was a cell phone? Would you say that was still okay? And he said, yes, I would. I think of it as a sort of spidey sense rule for when police officers can shoot, and it concerns me because Mr. McCarthy is going around training people all around the country that if you just have a feeling, you can shoot somebody, and that's okay. And it's not. That's not what the Albuquerque Police Department was told. What they were taught, according to Sergeant Fox and Jeff Noble, was that a weapon, particularly if it's a knife, is not enough. And that makes sense. It is, as much as they want to tell you, it's the same if you have a knife or a gun, they're both equally deadly. In fact, the statistics show, no, over 10 years where 598 police officers were killed, only 7 of those killings were with a knife. And the difference between a knife and a gun is if you can get a long way from me, but I can still shoot you from a long way away. But if you have a knife, as long as I create distance, I can protect myself and protect you too. What did Mr. McCarthy say? Mr. McCarthy said, you don't even need to see a weapon. That's the example I gave. I think you're doing something strange. I can just shoot you. I don't even have to see what the weapon is. I can anticipatorily shoot. And again, that's not regulation. The one thing they agreed on was this, that the 21-foot guide does not apply if guns are drawn. That is, if the officers have their guns drawn. Both of them agreed on that, and we gave you a whole demonstration about I heard enough about the Tuller drill, but you guys could teach a course on the Tuller drill. I think every single witness in this case talked about it. So if your gun is in your holster, this is the Tuller drill, you have to stay 21 feet away because it takes a second and a half for the person can get to you in a second and a half, all right? But if your gun is already drawn, you can, let me go back and do that again. You can move closer and you are safe even at 10 feet or less because the bullet travels faster than the person. And with your gun out, if somebody comes at you with a knife, even if they take 1 or 2 steps, you have time to shoot the person. And so you can be close to them if your gun is drawn. And here, in this case, it's not just if your gun is drawn, you have a dog in between you too. So the person can't get you because there's a dog in between you. Whether the dog would attack or not, if Mr. Boyd came down, he would at least have to trip over the dog trying to get to anybody. The dog was right there. But that's what these officers were trained, not just from the Tuller drill, but this is actually from what the defense put on about how you are safe if you have your gun out at 10 feet. Hold on a second, Judge. Let me see if I can turn on my sound here. My sound got turned off. Hold on just a second. Yeah, there we go. Okay, let me go back there. All right. This is from their exhibit on what these officers are trained.
For the average officer to deliver 2 rounds against an attacker who starts moving at 10 feet, the sidearm must already be drawn and ready to shoot.
So you can defend yourself at 10 feet. If you have your gun drawn at 10 feet, you are not unsafe. You are okay at 10 feet. That's what these officers are trained. I don't know if it bothers any of the rest of you, but it really bothered me that a lot of the examples they used were African-American people. The training, it just was a little disturbing to me, but this is the same, the African-American guy, and you shoot the African-American guy. But what else about this line? Here's what Jim Fox and Jeff Nobles both said. You have to have an attack. They have to not only have a weapon, have a threat, but they have to move towards you. And I think Jim Fox used the term, they have to be coming at you, is what he said. And here's where that comes from. By the way, McCarthy says, no, it's okay. I have a feeling, nobody moves towards you. I can shoot you whenever I have the feeling, I can anticipate the attack, and I can shoot you if I anticipate the attack. Here is the document that you saw on that too. This is the reactive control model. This is how all of these officers were trained. And this is what it says about what you have to have before you can shoot somebody. Or what a reasonable officer has to have. You have to have, it doesn't say a step, it says you have to have an attack by the person. It's not enough that you have, this whole red zone is where you have been made threats and you have a weapon, but you still cannot shoot until they cross this line and there is an attack. And here's the other thing, closes distance. And that's not that the officer closes distance, that I'm the officer and now I run up on you and now you're a danger to me so I get to shoot you. It is that the person comes towards you and closes distance on you, indicating that they're going to attack you. This is where the line was in 2014. That's where it was. No doubt, that's where it was. That's what Jeff Noble said. That's what Sergeant Fox said. This is where Mr. McCarthy wants to move it, maybe even further. I just feel I can shoot you, and Mr. McCarthy's going to come in and defend a police officer who shoots based on a feeling about somebody that they might attack them. That can't be where it is. But you get to decide. You can decide if you want it over here, that a police officer could shoot you if they just feel like you're in danger, or you could put it back here where it belongs, where these officers were trained at the time, that it's not enough that somebody's threatening you, it's not enough that they have a knife, they have to actually come towards you and attack you in some way before you can fire. And even if you're within 10 feet, you've got plenty of time to shoot. And you're not in danger, even if you're in 10 feet. Okay. Let me tell you what the case is not about before we get to Defendant Keith Sandy. This case is not an indictment of the Albuquerque Police Department as a whole. It is not. There are some good officers on the Albuquerque Police Department, and you've heard testimony from some. Jim Fox, I hope he comes back to APD. He is a fine, fine person. Michael Monette, a fine, fine officer. And even though the defendants have asked you to judge Mr. Boyd on his past acts, you cannot judge APD on his past acts. That's not what this case is about. It is not about the dangers of the militarization of the police force. Even though you've seen some elements of that here, the kind of weaponry they use and the body armor, it's not about that. It is not about taking a stand about police violence in other cities or in other places, or some of the things that you've seen on the news, from cell phone videos, or videotapes. It's not about that. It is only about these two officers and what happened on March 16th of 2014. And let's start with Defendant Keith Sandy. Defendant Keith Sandy was one of the most dangerous kinds of officers you can have on the street. Somebody who was out there with something to prove, whether it was to regain his reputation, whether it was to show how tough he was, or whether it was something darker. I'll let you be the judge as to what was going on there. He's the kind of man who I think defense expert Ron McCarthy said had no business taking place on. Because people who are out there not to do the right thing, not to protect people, are a danger not just to themselves, but to other officers and to every citizen. Defendant Sandy had been fired from the New Mexico State Police, you've now learned, and he was embarrassed by that. He was fired in 2007, and it was about the time that APD lowered its standards for lateral hires from other agencies, and so he was hired almost immediately back in to the police department at APD. And he worked his way to what I think he said in the statement was his dream job, that is not on the street, but as a tactical officer, a member of the ROPE team, the Repeat Offender Project. That is a group of men whose job it was to hunt down other men. And the men they hunted were repeat offenders, hardened criminals. It was a job that gave all of them, and you've heard some of the witnesses from the ROPE team, sort of a dystopian view, bad view of all humanity. And you've heard this cynical worldview from Defendant Sandy. It is a worldview that caused them to think the worst about ordinary human interaction. So, when James Boyd threw a sandwich and a dinner roll to the dog, Defendant Sandy didn't see that as an act of kindness or giving food to the dog. He saw it, and in his testimony, I thought he was gauging distance, seeing how far we were so we could do something or deploy a weapon in some way. That's how he saw that. When Mr. Boyd put on a sweatshirt as evening neared because it was getting colder, it wasn't because he was getting cold, it was because he was trying to defeat somehow their less lethal devices. When we asked defendant Sandy, was he expressing fear? No, he never expressed fear that armed men and dogs around him would kill him. All he did was threaten me. By the way, we have given you the transcripts, rather than just present one side of this, with, and I can't remember which one is which. I think it's yellow highlighted, is Mr. Boyd saying, I'm afraid you're going to kill me, I'm afraid of you, I'm afraid of you, I'm afraid of you, and then in blue highlighting when he threatened the officers. So you can go through and look yourself and see, really it's about 80-20 at the beginning, and then as the attack officers come up and get closer and closer to him, he becomes more and more threatening. These officers on the rope team say, we believe his threats, but you can't believe him when he says he's going to give up. You can't believe him when he says, okay, I'm going to walk with you, I'm not going to hurt you, I'm not a threat to you, I'm trusting you to keep your word. You can't believe him about that, but you have to believe him about his threats. And you can't believe him even when he turns. When they say, get on the ground and he turns, you can't believe that. One of defendant Sandy testified on the stand that he thought he was doing, he wasn't surrendering. He was trying to flank us, to get around us somehow, and to try to, the one guy with his two little pocket knives tried to take on all the 19 officers who were out there. That's what he said he was doing this day. What kind of person sees everybody as an enemy? Maybe the same kind of neighbor that sees a homeless person on the hill, and instead of offering them a sandwich or offering them help or calling the city to get them services, calls the police. And then after the police arrives, sets up a camera, 2 cameras on his balcony, and films them. From the moment he arrived, Keith Sandy made a series of intentional decisions that led inexorably to the death of James Floyd. What we said in opening is exactly what we're proving here for. This is the list of decisions we showed in opening. I will tell you, this is the only time you'll hear this. Mr. Brigham is right about one thing. I was wrong about the initial call. And there's another thing in opening that I was wrong about, and I'll tell you that when I get to it, okay? So here it is. I was right about the time. It's happened at 5:23. And it wasn't that he heard the request. He gets a call from the radio, calls his phone, and asks him to bring a taser shotgun. He responds that he has one. It wasn't over the radio. It was a phone call. That is correct. And he tells, within 4 minutes, by the way, by 5:27, dispatch calls back and says, we've got the wrong guy. They don't want you. They want the gang unit. They don't want rope to come out. They want you. They want the gang unit to come out with the taser shotgun. 4 minutes later, he says, cancel gangs and I'm coming. That's his decision to come. And then at 5:31, he calls his rope sergeant Ingram and asks him to call K9, assembles a party of men with guns and dogs to go up into the mountains after James Floyd. That's what he does. And then all of them get on rope air. We don't have wish I could give you a transcript of that phone call about what they said. Whether they cursed on those calls or not, because they don't do it, they're not being taped. That one is not taped. But they have a conversation where he briefs them all, even though it's not his call out, even though he's not the sergeant in charge, he briefs them all and says, let's all meet there. These 4 men, SWAT Officer McFarland, K9 Officer Weinerskirch, and Rick Ingram and him. And so they assemble this tactical team, and that's his decision to do that, to go up there after James Floyd. And then he grabs not just his taser shotgun, but he grabs his rifle. He arrives at 5:58, and down on the street, when he thinks he's not being recorded, he says when he's there, and no one said it, uses the F word, calls him a lunatic, explains that to you by saying, well, I call everybody a lunatic, including my son jumping in the hay. I bet he doesn't call his son an effing lunatic. And if he does, there's something wrong with him. This is probably the best example for you of what his intent was that day. He says right there, I'm going to shoot him with this taser shotgun, and he hasn't even seen him. Doesn't know anything about the call. That's what he says down there on the street, when he thinks no one is recording him and no one is listening. He then makes a decision to use his rifle as legal cover. he decides to be lethal cover. And he trades off his taser shotgun, hands it to the other rope officer who already has a taser shotgun and has his rifle. And you've got the picture in evidence that you can see, where he's walking up there with 2 taser shotguns and his rifle on it. He chooses to be lethal cover rather than use the taser shotgun. And then he says, and he didn't understand, I'm the one looking through my thing who says, I think these guys, these field officers who are up there, are too close and they're in danger, and I say to everybody else there, we've got to call them down, they're too close. And that's right, he wasn't the one that made the call, he didn't have the authority, but he's the one that made the decision looking through the scope. These officers are too close. That is hogwash, and you know it's hogwash because that's that place where they were too close. That's the same place they end up when they go up there. That's the same exact place they go to. And there he is down looking through his rifle. You've heard how Mr. Boyd reacted to this. When, instead of Michael Monette, who was negotiating with him and talking about how he's going to get him out of the hotel room, he's going to do things for him and try to get him off the mountain safely, when Michael Monette gets pulled down and Mr. Boyd sees these folks looking at him through rifles, checking him out up on the hillside, he becomes more and more agitated. Why are you pointing rifles at me? You know, and this is where he starts saying, I think you're going to kill me. I think you don't care about my safety, you're going to kill me. And that all starts with, and by the way, it's not a surprise when I say, oh, does anybody think Mr. McCarthy? Nobody ever reacts to the uniform. I'm sorry. Somebody shows up, like the life-size thing that you saw here, blow up with these guys with guns and hack military uniform. You're going to have a different reaction if it's some regular officer in a regular uniform. You are going to be intimidated by that particular outfit. What does he do next? Anthony Settler, this is the thing that was not on my list in opening but we found it in trial. Anthony Settler, the SWAT officer, arrives and sees Defendant Sandy looking at through his rifle up there at Mr. Boyd, and he says, let me take over for you. Let me spell you, is what he says. And remember Mr. McCarthy said, oh, it was not a bad thing to call down Michael Monette because sometimes CIT officers get tired and it's okay to replace them with somebody else who can start over the negotiations. That's not what Michael Monette said. That was not the way it worked. You talk to the officer and say, are you making progress? You think you can make more progress? If so, I will leave you there because you're doing a good job. If you're not doing a good job, we'll call some other negotiator to help. Michael Monette, who is the person who has never failed to talk somebody down in this situation. Never, until now. And it wasn't his decision to come down. It was these folks at the bottom of the hill calling him down because they said he wasn't safe. But when the same thing happened with Anthony Settler, when Anthony Settler came up to Keith Sandy and said, let me take over for you, he's a SWAT guy, not a rope guy. Keith Sandy says, no, I'll stay on lethal cover. Again, decides to stay on lethal cover. And now the interesting conversations that happened right before the SWAT team arrives. You've got these both transcripts, and I think you've also got the tapes that you can listen to yourself. Here's the first one, where Sandy and Weimer-Skirch and with Ingram standing there discuss a plan, begin to discuss a plan in quotes because it was not a very good plan, and it doesn't sound like everybody was on the same page of the plan. They talk about how the taser shotgun, we can't use both things. We can't use the taser shotgun and the dog at the same time. If we shoot him with the taser shotgun, because of this jellyfish thing, these wires that come off, what's going to happen is the dog's going to react badly to that and not bite because it can feel the shock, and that's how they're trained with these shock collars, to not bite. And so they talk about that, and everybody supposedly that the three of them knows you can't use both at the same time. And then, 10 minutes later, this is captured on air. Sergeant Weimer-Skirch, the canine officer, seems to say we've got less lethal tools coming. By the way, because they never talked to all the field officers who were there, they didn't know that there were already less lethal tools there. They already had 2 beanbag shotguns on premises. They already had 2 CIT officers on premises. They called for CIT and they called for beanbag. They don't even know that they're there. And why are they doing this anyway? Because the person who's supposed to be in charge is Sergeant Carpenter. They're just sort of taking over the whole thing. Come in and just start making decisions and doing things without checking with Sergeant Carpenter or anybody else. And what canine officer Weimerskirk says, let's wait, you've got less lethal tools coming, let's wait for that and wait for more manpower. And one voice says, no, we can do it. We can do it. The three of them alone. And that voice is Big Sandy. And that's who says that on that tape at 7:16. And then the thing that changes everything happens. You think at that point they made a decision not to go up. By the way, you have got an instruction that you cannot consider the failure to use less lethal tools like the beanbag shotgun for the issue of justifiable homicide. You can consider their failure to wait on the issue of intent and what defendant Sandy was actually doing. Why didn't defendant Sandy wait for the beanbag shotgun? Why didn't he wait for more manpower? And by the way, McCarthy says there's nothing wrong with this. Even though the defense has argued there was something wrong, the canine officer made a mistake, their experts said nothing wrong. I let him do it the same way. And it's something completely different than what he testified about in a whole other case, where in the other case that he testified, he criticized them for having 3 men go into a arrest situation, a dynamic entry, when they had 10 men available. He was critical of them. He was also critical of them and said, this man in that case, the officer in that case, was not faced with an imminent threat. And how do I know that? Because all the shots that he shot did not come in the front of the man. They came in his side. Now that's what he said in the other case, something different than what he said to you today. Anyway, sorry, back to the story. 7:20, we all know what happens. Sergeant Fox arrives and he says, I'm here. And what does that mean? And what does every single one of them know that it means, all 3 of the men on this entry team? It means that they're not going to get to go do this arrest. Because when the SWAT team arrives, the SWAT sergeant takes over, and they replace them with SWAT officers who have trained together, who know how each other works, who knows what their plan is, and they know they're going to lose this arrest. And it is that moment that causes them to decide to go up next to where James Boyd is, right back to the place where they said those other officers were not safe. And it should be instructed to you on their intent that they don't tell anybody what they're doing. Not only do they not tell anybody what they're doing, but their plan, in their plan that they're supposedly conducting an arrest, there is none of the 3 of them that is assigned to go hands-on and arrest this man. None of them were assigned to arrest him. Unlike the CIT officers, defendant Sandy wasn't there to help Mr. Boyd. He was there to hurt him, just like he said down the street. Although there are 2 very different officers, and I've told you that from the get-go, they are both charged with the same thing. And that is second-degree murder. And let's talk about the UJIs that the court just read you. This is the second-degree murder instruction. We're going to talk about the easy parts of this instruction. We'll talk about the harder parts for your decision. All of these except for 3, I think there's no dispute about it. These 2 defendants killed James Boyd. Both of the defendants knew that their acts created a strong probability of death or great bodily harm to James Boyd, and this happened in New Mexico on or about the 16th day of March. As far as intent is concerned, both defendants took the stand and said, it was my intent to kill him, or shoot in center mass with the understanding to suffer great bodily harm with the kind of weapons we were using. We intended to. It wasn't a mistake, it wasn't an accident, so you have intent. So the question then is, this, 3, and we have the burden of proving this, again, not beyond all possible doubt, but only based on beyond a reasonable doubt. The defendant did not commit an act of justifiable homicide by a public officer or employee, or in defense of another. Those are 2 defenses that they were raising. We have to prove that did not occur. Let's talk about this one first, the justifiable homicide instruction. This is the element right here. There's 2 elements that you need to consider here. The other, I think, are not contested. Were these officers, at the time they killed Jim Floyd, overcoming the actual resistance that he was giving them to the discharge of the legal duty to arrest him for the felony crime of aggravated assault on a peace officer? That's the first element. Okay? And here's the fact that defeats that defense. You can't be resisting arrest unless you know you are under arrest. Not only did these officers all admit that they never told Mr. Boyd he was under arrest, but as part of this ill-conceived plan that the three of them came up with, they were planning to trick him into coming down, so that they could attack him, coming down the mountain. And they did that after Sergeant Cox arrived at 7:20, and we played you 5 different clips. So we yelled, but we insisted they give up his knife. We played you 5 different clips after 7:20 where they kept saying, well, come on, just grab your bags and come on down the hill. Grab your bags and come on down the hill. And they never said, and you've got to put your knives down. You have to put your knives away beforehand. You okay, Ms. Sprague? You okay?
Yes,
Okay.
I'm fine. I'm just
Okay.
making sure it's said that there's the actual
Okay.
jury instruction.
Yes, sir. I think it is. Let me know if it's not. Where was I?
Let me just
Yeah.
remind you to talk to.
I'm sorry, Judge. Okay. All right. They not only didn't tell him he was under arrest, they told him the opposite. They were trying to trick him. They told him, and poor Mr. Boyd believed him after talking to him for 2.5 hours, that he was going to be allowed to come down and give him safe passage and have transcript of what he said to them. I'm trusting you. As he picked up his bags, he didn't want much. He said, you don't even have to put me up in a good hotel. You can put me up in a Motel 6. I'm not sure that's good advertising. The Motel 6 company. He said, put me up in a Motel 6. And the officer said, well, you know, how you know that he was under arrest is when you can't leave. That's how you know, that's how somebody knows they're under arrest. They told him the exact opposite. You can leave. You can come down. We're going to give you a voucher for a hotel. All that you heard was a lie to trick him into coming down so they could pounce on him. So when, in all of this, was the first time that Mr. Boyd would realize that they were not telling him the truth, that really they were going to arrest him? When is it? They say to you it's the very first time that he says, that they say, get on the ground, which is right after the flashbang grenade happened. They threw the flashbang grenade, there's all this smoke. This is the first time I think this slide, Exhibit 9E9, when Defendant Perez said, I told him to get on the ground. Well, first of all, the flashbang just went off, get on the ground. He's still figuring out what the heck is going on. There's just been a giant explosion at his feet. The next time he tells him to get on the ground is here, when he is leaning forward to defend himself against a dog. And I suspect he's not getting on the ground when there's a dog running on him, whether he even heard get on the ground at this particular point because he was defending himself against a dog is anybody's guess, whether he even heard it. And they say, they continue to say get on the ground, they say it 2 more times, and at some point, and watch the video, the most important evidence in this case is the video. When somebody tells you something, check it out the video. Okay. You can see the realization going on with the court. As they continue to say, get on the ground, get on the ground. And indeed, he pulled his knives out in response to the dog to defend himself against the dog. He has them out for, like this for about a half a second, and then he drops them to the sides, and that's where they stay. And you can see it dawning on him that they're not letting him go down the hill, they're not getting him up the hill. He's not going from up on the mountains to a better place. And now he has a decision when he realizes that they're arresting him and assaulting him. To fight, to flee, or to do what they say. You can see him deciding that. And his decision is to say, don't make fun of me. Basically, you didn't keep your word, you betrayed me absolutely. And then he makes the decision to obey their order and turns. And he continues to turn until he goes down on the ground like this. Here's the thing about physical evidence like a video, it cannot lie. It is what it is. No matter what the post-shooting testimony is about he was trying to flank me or changing the statement that defendant Sandy gave right after the event that this was a defensive posture, not an offensive posture. He now said, oh, what I meant by defensive is that he was getting ready to fight. He was getting ready to defend himself. That's not what defensive means. Defensive means he was defending himself rather than doing an offensive posture where he's attacking somebody. But don't listen to the words, look at the video. And what does the video say about the second defense of whether reasonable persons would have reason to believe he posed a threat of death or great bodily harm to another? And this is the second element you have to consider, defense of another. And in order to figure this out, the immediate danger of death or a reasonable person in the same circumstances, you have to go back to where we started with the rules and the standard operating procedure. Because the training these officers receive tell them what the go signal is, but also what the stop signal is. And what is the go signal? It is not the weapon, not the threat. It is an attack or closing distance. That's the go signal. It's not I'm calling you names or I'm threatening you or I pull out my knife. That's not it. And that's how both these officers were trained. At the time of their statements, this is very important. Remember, they had 2 days to think about it, get their stories straight, talk to anybody they wanted to. Both had the same lawyers. They both come in and they both have the same lawyer. They come in and they both make a statement that's very similar in one particular respect. Mr. Sandy comes in and says, I'm very legalistic, because these men have been trained in what constitutes defense of another. Here's what Defendant Sandy says. I made the decision that because of the proximity and the knives that I was going to engage him with my rifle. So he says, Defendant Perez, it was at that time I decided to use deadly force on the suspect to save the lives of those officers who were in close proximity to him. And that word proximity is very interesting because it's not a word that anybody ever uses in discussions or talking. It's a legal term to set up the defense of another. And because both of them, I think, knew they did not have the green light to go because they don't have an attack or they don't have closing distance, and neither one of them said that he attacked them or lunged at them or even took a step towards them in their initial statements 2 days afterwards. They came up with the proximity level. And that distance, the proximity between them since the time of their statements has gotten shorter and shorter and shorter. Although you know what the distance is because the only person who actually went out and measured it was Barry Getz. And he says he located the points on the video where Mr. Boyd was standing, he located the points where these officers were standing, and that distance is 12.9 feet. That's what it is. He measured it. And it was 29 feet, he says, between Defendant Perez and Mr. Boyd. What did Mr. Sandy say at the time of the statement? He said at the time of the statement that when Mr. Boyd pulled out his knives, that he was 20 to 25 feet away from him. And of course, Mr. Boyd didn't close distance on him. Sandy and Weimerskirch closed distance on Mr. Boyd and ran up to him, and the closest that he said in his statement he ever got was between 10 and 12 feet, which is closer to what Mr. Getz measured. What did Defendant Perez say? At the time of his statement, he said it was, again, 7 feet, closer, 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 because the closer I am, the more I can say for a threat to somebody. And then he came in here at trial and tried to tell you for the first time anywhere that, oh no, he thought it was arm's length, that these officers were with arm's length with him. Let me suggest to you that the true statement, the statement that is closest to the truth, is the one that was given 2 days afterward, after they had all the time and all the luxury in the world to say whatever they were going to say. They keep trying to put Mr. Boyd closer and closer to Officer Weimerskirch because they know that they don't really have what is required to justify deadly force under the reactive control model. Now, that's what Jeff Noble said. What is actually required is a movement towards you, an attack. And that's what it says. It doesn't say a step, by the way. It says closes distance or an attack, and closes distance on you. Not step to the side, but close distance on you. And here, let's talk about the phantom step the defense has talked about. They asked specifically Jeff Noble, here, let me show you this video. Isn't he stepping towards the officers? And he takes that step, can't you shoot him? And Jeff Noble said, there's not a step there. There's not a step there. They keep trying to create a step from the video that is not there. And let me show you. Oh, sorry, there's the line again, sorry. Hold on, let me get out of here. The phantom step is where we are. Here is where they try to create from the video what I call the phantom step. It is right here where Mr. Boyd does, you see it? Right here. And don't, again, these are just frames from the video. Watch the video. When the dog runs up to him, and I think that shows that the dog comes back at him again, he gets sort of knocked off and he goes side to side. He doesn't move towards the officers, he doesn't close distance. And how do you know that? Because look at where, here. If I go side to side, you can see, I don't want to be too obscene, you can see there. If I step towards you, this is what it looks like. There's not a triangle between my legs. I am stepping towards you. But you don't have to rely on just this video. I think somebody in jury selection said they wish they would have 360 video. We don't have that, but we've got this. And as much as I think Mr. Dixon is a little odd, I am glad we have this video because you can see that Mr. Boyd never moves towards the officers. The one thing you'll see in this video is when the dog runs up, he bends over like this to put his hand out for the dog, and then he stands up, and you never see him close distance on the officers. And here is the video from Mr. Dixon's camera, exhibit 13B. Bends over for the dog. Never moves towards them until he turns to lay on the ground and they get shot in the mouth. Never closes distance. Not only did these officers not have the go signal, and you've got to have that before you ever shoot, but they got the stop signal as well. You have the standard operating procedure and evidence. It is Exhibit 1. It's the whole procedure for the APD on use of force. Read through it. What it says is you must stop the use of force if a person is no longer an objectively reasonable threat and no longer an imminent threat. Even if you had the go signal, you got to stop when they stop being a threat to you. Judge, I'm sorry, could you turn on the Elmo, please? Yeah. Oh. Green coloring out there. And just talk about whether he surrendered, was he surrendering, or was he flanking, what was he doing? Probably the most important testimony of the case on that came from Defendant Perez himself. Defendant Perez admitted the following in his testimony. Question. If in fact you saw him turn around and his back was to you at that time, he was no longer an imminent threat to you, was he, when his back was to you? And Defendant Perez said to you, if that was the case, he was not an imminent threat. When someone obeys the orders, when someone turns their back to you, they are no longer an imminent threat and you have to stop. We know that Defendant Sandy, from his own statement, saw him turn before he shot, turn to his left. That's what he says. He saw the stop signal, the same stop signal that Ron McCarthy said is why he didn't believe in that other case the man was an imminent threat, even though that man had a gun because all the shots came this way across him. And this is the other thing I got wrong in the opening statement. The order of the shots. The first two shots, first shot happens as he turns, goes here. Second shot happens as he turns here, and the third shot comes across here across his sleeve. That's the other thing I got wrong, so I want to make sure that I correct that for you. That's the order of the shots. That's what the expert testified about. That's how they happened. And then after those shots were over, defendant Perez began to shoot his first shot. It went into Mr. Boyd's back as he was stretched out this direction. That's how it goes across like this. Let's talk about, here's the stop signal. I think let me just show you these. I think you've seen these plenty before. There's the turn that they saw, turn, turn, turn. There's the shot that Don Perez took when his back was to him. And let's talk just for a minute about Don Perez. Although these men are charged with the same crime, they are not the same kind of police officer. And I have been honest with you about that since jury selection. He's a different kind of officer than he's saying. And we have not objected to character evidence coming in about him because I think you need to know who he is. I think you need to know who both these men are. He was not up on the U-mound with any ulterior motive. The state would have it, he was the one who was ordered up. And here is the problem with all of that, and what makes not just my job as special prosecutor so difficult, but will make your job difficult in deciding this case. And that is this fact. If there was not a go signal for Keith Sandy, who shot first, because Mr. Boyd never actually attacked, and if there was a stop signal for Keith Sandy where he turned and he shouldn't have shot, then the same is true for defendant Perez. And even more so because he shot second. So he should have seen him turn. He should have seen him turn around. And he knew, and I think he's admitted, he never saw him step towards him, move towards him, lunge towards him. None of that ever happened. He didn't have to go signal even to begin with. There is one additional charge in this case that you only get to if you find that Keith Sandy did not convict, and it's only against Keith Sandy. You find that he did not commit second-degree murder. You move on to aggravated battery. Here's the issue that creates the aggravated battery lesser included. I don't think it's disputed, and the only evidence that you have is from the Dr. Sam Andrews from OMI, who doesn't have a bone to pick or a dog in this fight, who says this man died because of both the injuries from both bullets. The one to the arm that caused him to cut his arm off here, and the one to the back that went through all of his organs between here and there as he was running over. It was blood loss from both of them. The instruction says if any shot contributed to cause the death, that's enough. It doesn't have to be one shot caused the death or the other shot caused the death. So there's really no dispute about that. But if you think there is a dispute, and you think maybe this one where he lost his arm didn't cause his death, that's how you get to aggravated battery. That's essentially what that's about. I want to end. With James Boyd. You know, thereby fortune and good grace go every single one of us. Anyone can be inflicted with the curse of mental illness, or dementia, or PTSD. And I can't remember if it was in jury selection or from the witness stand. Somebody said, you know, all of us are just one big disaster away from being homeless. If there was some catastrophe in our society, if there was a flood or a tornado, any one of us could be homeless. Any one of us. Could be wearing a straight t-shirt. Mr. Boyd had found a solution that worked for his very difficult life and his very difficult disease. He was camping in an open space where he wouldn't be a bother to the rest of us. Close enough to walk down for fast food. He pitched his tarp 300 yards away from the National Forest. As you heard from Sergeant Ware, if he just moved, if he just showed up and said, you gotta move your tent 300 yards that way, that would have been the end of it. He wouldn't have even been committing the crime of illegal. On March 16, 2014, he was in his tarp watching a movie and eating a fast food dinner, and he was not bothering anyone. The defense has played clips in opening and throughout the trial over and over again, multiple clips from different people's taser cameras, often of the same thing, saying the same thing. I'm threatening you, I'm going to tell you, I'm sticking this knife in your neck. Thanks. They are hoping that you will do the same thing that Keith Sandy did, that you will be afraid of Mr. Boyd, and that fear will erase his humanity in your mind. Mr. Boyd was not an enemy combatant. He was not a dangerous animal that needed to be bagged and tagged. He was a mentally ill man who was having one of the worst days of his life. A man who was afraid and who said he was afraid that the officers surrounding him were really there to kill him. He was a man trying to find a way to come down from the mountain, from his tarp, to maybe a better place like a motel. He is no different from any of the people in crisis that Mike Monet successfully brought in. Never had a failure. Never. He's the kind of person that the police officer is supposed to be trained to deal with every single day. And the saddest thing of all is that Mr. Boyd was right. They did kill him, and they should not have done so. This was not justifiable homicide. It was not a defense of the officers. And you should convict both of these defendants of second-degree murder. Thank you.
Your Honor, save 5 minutes for rebuttal, if that's all right with the court.
Sure. Bill, return the exhibit.
Yes, go ahead. I sure will.
And let me have counsel approach real quick. We can proceed in one of two ways. We can take 5 minutes, have you come back out, listen to another hour of closing, and then break for lunch then, or we can break for lunch now, and then you'll have another 2 hours of closing when we get back from lunch. So just want to check in and see how you feel. So show of hands for taking lunch now. No. Show of hands for taking a quick break and then have another hour, taking lunch later. Everyone's in agreement? Okay, so we'll do it that way. Please stand.